Court does call the case of the People versus John Torres.
Good afternoon, Your Honor. Patricia Reiser on behalf of the people.
Good afternoon, Judge. Joshua Van Lon on behalf of Mr. Torres, who's present to my right. Sir, can you tell the judge your name, please?
John Torres.
All right. And you had previously read and reviewed the pre-sentence report. We've been here a few times.
That's correct, Judge. No additions, deletions, or corrections. We've talked about those already.
All right. And there's nothing else you'd like to say?
No, Judge. What I would indicate is the court has given us plenty of opportunity to think about this case, figure out how we want to proceed. We won't be withdrawing the plea. We'd like to go forward, and we rely on the prior statements that were made. Sad case. It just is.
All right. Both moms are here, I think. And ladies, I know you've had also an opportunity to address the court, but is there anything else you'd like to say to the court?
No.
No? All right. Let me just say this, and in part, I will say this to the victims' families. One of the things that I promised you more than anything else is that as we, I don't think it was the last hearing, but the hearing before, is that sometimes there can be a feeling that you're not heard. And the one thing that I promised to you is that at least as far as this judge, you would be heard. I would listen to you in your position. And I believe at the last hearing that I laid out that I'd looked at additional things prior to the sentence. I will also say that I have quite a hefty caseload in things. This is one of those cases that weighs very heavily on the court. In a lot of ways, because as I sit here, you always are trying to do the right thing. Both in terms of any victims and their families, as well as in terms of the defendant. And sometimes it's very difficult to reconcile that, to come up with and fashion something that can in one way make sense, and in another way allow everyone to, but particularly the victim's family, to have some closure to the tragedy. I can't bestow upon you, can't give to you in any way absolute closure, because some of that comes with time. Some of it, frankly, and it's a hard place to get to, comes with the notion of forgiveness. As I indicated before, and rarely do I take people through my entirety of my thought process, and I won't share it all, but I'll share these parts. That day, all of those involved had certain responsibilities. And I'm not, and believe me, folks, I'm not trying to blame anybody necessarily. One of the things with drivers is, and I think anybody that's a parent, when their child begins to drive, that probably one of the hardest things to explain to them is that they have a certain responsibility when operating that vehicle to always have that vehicle under control. In a lot of ways, regardless of the circumstances, you have to have that vehicle under control. And then by the same token, you also explained to them that should something happen, regardless of what the circumstances are, you don't let your emotions or what we commonly might know of as road rage sort of take over and allow and do things that, quite frankly, in the grand scheme of things, make absolutely no sense. That's the problem I have, quite frankly, with you, Mr. Torres, is that you did something that didn't make any sense to me. Because it's almost like that road rage circumstance where all of a sudden you're, I think, causing this thing to happen. By the same token, and I say this with all respect to the family, I think you know how I feel about you guys. The young ladies in that car then have that other responsibility that I'm talking about, that you pray to your kids that they'll pay attention to, that they keep that vehicle under control regardless of anything else, that they just drive and do things safely. Reality is that at times when these things are going on, people aren't thinking. And then they're saying things one way after the fact, and that may not match up with something. Doesn't make any sense in a lot of ways. I wish, maybe, I guess I wish that the powers that come to me to be able to impose a sentence, if I could just put everybody back, that would make me the happiest. But I can't, and I know I can't. That is the greatest frustration. I also know that I could follow this recommendation to the letter, impose the jail time 45 days from now, outside of the probationary period, when Mr. Torres walks out of the jail, nothing's changed. Nothing. And so, in that respect, what have we really done? What I don't want more than anything, and this may be a sort of weird way of doing it, but I don't want those two young ladies ever forgotten. That's what I don't want. Whether I send them to jail, don't send them to jail, I don't want them forgotten. Those were two vibrant lives that, given all the circumstances that day, are no longer with us. And so I hope the family can understand what I'm about to do and can appreciate it. I'm not, sometimes when people look up at the robe and everything else, they think we always have the answers to everything, and I don't. I freely admit that. But I just do the best that I can with what I have in this. And when I boil it all down, I don't want your daughters forgotten. It is therefore the sentence of the court You were placed on the maximum probation that I can sentence you to, which is 24 months probation. I'm going to increase the fines and costs in this case, and you are to pay $1,555 fines and court costs, $720 probation oversight fees. When can that be paid?
Today.
That's to be paid today.
Yes.
There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete a driver improvement course as directed by probation. I'm going to order that you complete 100 hours of community service with proof to probation. I'm going to order that the defendant, I'm going to order 90 days in jail, credit 1 day served. The defendant will serve 45 days of this sentence, but that serving of those 45 days will not begin immediately. The defendant is ordered to report to the Washtenaw County Jail on Friday, August 2nd, 2024. It will be the third anniversary of when this tragedy occurred. When you report to the jail that way, and it's all that I can do, those two young ladies will have to be remembered on that date. The remainder of the sentence is suspended. I will tell you, Mr. Torres, if you do not follow my orders in this sentence to the letter, those other 45 days will be served by you. Am I understood?
Yes.
Thank you.
Thank you, Your Honor.
Why don't you guys wait until they, well, let them leave and let them wait for a moment.
Officer Cole is present. Grab his finger.
Just give them a minute to get down the hallway. Everybody else I trust. I don't trust the guy on the end. And you know why. I don't forget anything. Sorry, folks. It's best I can do. I tried.
Judge, that fine was 1,055 or?
I kicked it up to $1,555. Again, it doesn't do much, but at least make it hurt a little. So it's a signed copy.
Yeah.
Okay. All right. All set? Oh, he's at the counter. Okay. All right. You guys take care of yourselves. No, go ahead. You can go. Just behave yourself.
Yes, sir.
You guys take care.
Yes, Your Honor, I'm here on Zoom.
Hey,
Your Honor, this is Nancy. Your Honor, Nancy Gerler, appearing on phone Zoom.
Yeah, I will read it for just a moment.
All right, and where are we on this case?
Your Honor, good morning. I am requesting a money judgment from the court for a total of $12,238. This amount includes unpaid rent of $12,950, court costs of $215.
Say that again. How much is the unpaid rent?
The unpaid rent is $12,950. The court costs are $215 and the service fee was $68. And I'm refunding the security deposit in full, even though the apartment was not clean to the degree that, yeah,
Hold
anyway,
on. How much was the security deposit?
what?
How much was the security deposit?
It was $995.
Okay, so let me ask this question.
Yes.
If you're requesting a money judgment and there's rent owed, why are you returning the security deposit?
Oh, no, I don't. Oh, I'm deducting it from the rent owed. And the balance, the balance owing is $12,238.
I see.
Does that make sense?
Well, $12,238 or something after you deducted the security deposit out. She's no longer in the unit.
Right. She moved out on February 2nd at midnight.
All right, Ms. Gerler, what do you have to say about that?
Your Honor, number
Yeah.
one, there was no inventory taken upon move-in. Therefore, she has no claim against the security deposit, which should
That's
be
not,
applied.
ma'am, let me stop you there. That's not true. Because under the Security Deposit Act, if there's rent that's due, she could take the security deposit for past due rent.
Oh, absolutely, and I volunteered that in court, December 20th. I told her she could keep that rent for
She's done.
January's, the damage deposit
About the
for
rest of the,
January's rent.
so what do you have to say about the rest of the monies owed?
Your Honor, I have presented to you previously. I have been subject to chronic illness, and there are now 4 separate occasions where Ms. Peel was not cooperating with myself or agencies to assure monies for her. As I mentioned previously, Faith in Action had offered her monies that she refused. I knew that we could be brought current up to the $3,000, almost $3,000 owed at that time in July of 2022 when she declined to take the money. My conclusion was she wanted me to move, and Ms. Biles at Faith in Action said that the $2,000 allocation I could then use to help me move, put down security, and first month's rent. I proceeded to attempt to move, started organizing and getting rid of things, getting things out of storage, and got sick again with COVID in August of 2022. I was served another notice to quit December 2nd, 2022. After I had spent all of November emptying my storage units to get to the large furniture items, I told them I would sell, give them monies, which I proceeded to do
Ms. Gerler.
in December.
Ms.
Sir,
Gerler.
I'm telling you. Okay.
And you don't want to yell at me.
I didn't mean to, sir. I'm sorry. I also have post-traumatic stress disorder, if you'll recall.
Okay, that's fine, but you do not need to yell at me. I am trying to stop you because what you're telling me seems to me to be irrelevant. That would be relevant to the issue of possession, but you've given up possession of the unit.
I have given up possession of the unit.
She is asking for a money judgment.
Exactly, sir. So, I have attempted to pay her money and do whatever I could to pay her money all the way along. In January of 2023, she asked me, could I pay at least $500 a month, which I did consistently.
Ma'am, are you saying you do not owe this money?
I'm saying that any help I tried to get from any agency to pay her, including Hawk, after our last court date, I had an appointment with Hawk on December 18th. I believe that Hawk was still out there to help me with this money judgment. And I checked back in with Hawk.
Ma'am, they won't help with the money judgment. They will help you maintain your tenancy by paying if you're gonna remain in the unit. But you're out of the unit now.
Sir, Ms. Peel did not return the calls on December 19th or January 3rd from Hawk reaching out to her to try to assist with this situation. They closed the case. There might have been help from them and their affiliated agencies, but there are 4 occasions when I attempted to get help from other agencies, including the Department of Health and Human Services, when the situation where fraud might have been done in the name of another tenant wasn't cleared up for me either. So no, I do not feel that I owe the full judgment here. I have done
all right, that's fine.
I could.
Ma'am, that's fine. So here's what I'm gonna do. I'm gonna set this for trial. Both of you need to appear in person. And I'll just have a trial. You guys need to bring all your paperwork. Because what you're explaining to me, ma'am, would be rental assistance if you were going to stay in the unit. You're no longer in the unit, but you feel that you don't owe the money. If you don't owe the money, then that's gotta be hashed out and we're gonna have a trial.
Your Honor, I do not feel that I owe the full amount and feel we must go to trial to do this.
That's the way we do it. It's a court. So we have a trial.
I am very sorry to see things go this way, Your Honor. I have done the best I can under my limited circumstances.
You don't have to be sorry about it. It's what I do every day. So.
All right, Your Honor.
So we'll have a trial. Emily? Abby, when can we have a trial?
Okay,
Hold on. I'm just trying to get a trial date. Just hold on. As soon as she decides to give me one, we'll get it. Emily?
March 7th at 9 a.m.
I'll set your non-jury trial, March 27th. 2024, 9 a.m. That is in person at the courthouse.
Your Honor, you do realize that I have great difficulty being in Wi-Fi and all of the.
You have great difficulty in what?
In being in your courtroom because of all of the electromagnetic frequencies in your vicinity as well as the courtroom. That's why I'm on phone Zoom every time. I suffer
I'm setting it in, ma'am. I'm setting it in person. If you send me something medically that may make me change my mind, then I may let you appear via Zoom, but I'd have to have something from a doctor that the court can check out. Otherwise, I will expect both parties in person.
Yes, Your Honor, I will present to you that evidence, and I appreciate your consideration. And
I'm making it
Sir, sir.
right now that this is set for non-jury trial in person.
All right, and sir, I just want to let you know, I was not yelling at you. My microphone was all the way turned up and I.
Ma'am, it's okay. If you were yelling at me, I just tell you don't do it. I get what you're saying. That's fine. I've been yelled at by a lot of people. Doesn't bother me. Thank you.
Sir, you do not deserve it. Thank you, goodbye.
You're right. I don't deserve it. Thank you. All right. Who said that? Alan. You need to calm down. Say too much.
Recall the Wayne Green. Prosecuting Attorney Morgan Barroso on behalf of the people.
Bridget Coons on behalf of Mr. Ostermiller. Mr. Ostermiller, state your name for the record.
Jeffrey Ostermiller.
Claire on behalf of probation. Your Honor, Mr. Ostermiller is scheduled before the court today on a violation of probation. Mr. Ostermiller was arrested on February 24th, 2024 on a violation of the contact order. So the court is aware, Mr. Ostermiller at that time did have no non-consensual contact with the victim in this case. There was an incident that took place at her home. She asked him to leave. And in the police report that I reviewed, Your Honor, it took him multiple minutes before he left the premises or left the house. He was in the garage when police arrived, and he was arrested due to the contact order. Mr. Ostermiller was in custody. He was arraigned. The magistrate then put in place a no bond with the victim in this case, and bond was set. Mr. Ostermiller posted bond on February 26th, and he was released. Since that time, Your Honor, I did receive documentation from the victim in this case where Mr. Ostermiller has continued to communicate with her, multiple communications via text, emails, Google Docs, and I have provided all documentation to the court.
Yes.
Given the continued violation of the contact order and the prior violations from Mr. Ostermiller in this case, in entirety, probation is now asking that the court sentence Mr. Ostermiller to 93 days in jail, credit for 27 days that he's served on this case, and to serve the balance. But the court applied the bond that he posted recently, which was a $5,010%.
What makes a judge lose patience with a defendant? In this courtroom, the answer becomes clear. Ostermiller is back before the court on a probation violation, and this isn't his first warning. According to probation officers, he was arrested after allegedly violating a court-ordered no-contact condition, one of the most important rules imposed in cases involving personal disputes. Prosecutors argue that the violations didn't stop there, claiming continued communication through texts, emails, and other messages even after his release. The defense points to progress. Miller says he's attending therapy, participating in treatment programs, maintaining sobriety, holding a full-time job, and trying to rebuild relationships with his family. On paper, it looks like someone making positive changes. But in court, compliance isn't measured by good intentions alone. Judges often focus on one key question. Did the defendant follow the court's orders? As the hearing unfolds, the judge begins examining not just what happened, but why it happened. And what follows may determine whether months of progress are enough to outweigh repeated violations of the court's trust.
If you need me to come down, I can make every arrangement possible to try to come down.
And what I'll do is I'll adjourn this matter to 3 o'clock. Well, what time is it? 1:30? I'll adjourn this matter to 3:30.
Thank you.
Thank you.
District Court for County Washington, State of Michigan is now back in session.
You may be seated. Court does call the case of the People versus Ostermiller.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Bridget Coons on behalf of Mr. Ostermiller. Oh. If you can, state your name for the record.
Jeffrey Ostermiller.
All right. I think we went through on Zoom the violations that are alleged and the recommendation, but you may go ahead, Ms. Coons.
Your Honor, at this time, my client would like to admit to the violations. And we would be asking that the court depart from the recommendations for good cause. He is, as far as the no contact goes, we in no means mean to excuse it. But he received 7 texts before he replied to the victim in this case. Again, I'm not trying to mitigate it. He understands that that was against court order, but he felt that at that time it would have been okay to reply since she was texting him so much. As to everything else,
So which about the first incident then?
the consensual contact or non-consensual.
That turned into non-consensual contact.
So as far as that goes, Mr. Ostermiller, I think that there's an issue with the police report. Our focus is more so he admits to the text and calls. As to the consensual contact, he was told to leave. He was packing his bag. The police had arrived to the house.
Before I was told to leave. Correct.
Yeah. And then at that point, he was arrested. He is currently inside individual therapy. He goes once a week. He discusses issues like this, including his relationship. He even has an appointment today at 4:00. He's currently in the domestic violence program. He's 12 classes down, has one that he's supposed to go to tonight as well. He completed the intensive outpatient program, finished that inside November. He's been compliant with the sober link. Currently,
5 days.
5 days.
5 days shy of my 6-month chip.
Yeah, 6 months sober. He goes to AA meetings daily and does have a sponsor with the 12 Coconuts home group. He does have a full-time job and works inside the IT department. He has 2 upcoming huge projects with deadlines that he'd like to try to meet, as well as he's in the process of reconciling with his children. I do have 2 letters from Recovery Technology and Hagira Health Incorporated. He went to their programmings and both of them said that he was doing well in them and he was very much participated inside the activities. So we asked that he be allowed to continue with probation. And I think that he is apologetic about the scenario.
Anything from the people?
No, Your Honor, we ask that you follow the Ms. Flores' recommendation.
All right. Anything else from probation?
Nothing further, Your Honor.
All right. Mr. Ostermiller, we've tried to work with you through this case, and the reports I get, and it's part of the problem is that rather than following what should be done, you always want to do things your own way, and we allow you a little bit of latitude, and you just continue to not follow what we're asking you to do. I don't understand after being arrested the first time, why even after 7, 10, 15, 20 texts, I don't even understand why you respond. I don't even get it.
I should have blocked the number. I should have done anything but contact her back. I should have. I take full responsibility for that. It was a lapse in judgment. It was a lesson learned that will never be repeated. Until the day that I die, I will never contact Ms. Mason, make any attempt to contact her, go to her place of residence or work, or anything. I want to be as far away from this woman in this relationship as possible.
Anything else you want to tell me, sir?
I made a big mistake. I made a big mistake this week. It is not a mistake that I will repeat ever.
I just don't understand. I'm going to waive all remaining terms except the financial obligations. I'll discharge the defendant from probation without him.
This is the turning point of the hearing. Notice what the judge keeps returning to: accountability. The defense argues that the alleged victim initiated contact repeatedly before Miller responded. From a personal perspective, some viewers may understand the temptation to reply, but legally, that's not usually how no contact orders work. In many cases, the responsibility remains on the restricted individual to avoid communication entirely, regardless of who reaches out first. That's why the judge appears focused less on excuses and more on decision-making. The court has already given opportunities, supervision, treatment, and probation. Yet the concern being expressed here is that Miller continues to make choices based on his own judgment instead of strictly following court directives. And that's the question hanging over this courtroom right now. Should rehabilitation efforts outweigh repeated rule violations? Or does ignoring court orders erase the progress that has been made elsewhere?